Tout d'abord, un grand merci de m'avoir invité. En fait, c'est ma première fois d'être à l'ULB pour une conférence. Donc,
c'est un plaisir.
je vais faire en sorte, ou essayer au moins, de vous présenter mes idées d'une manière le plus claire possible. Mais je vais vous avertir tout de suite. Je suis un juriste et mes idées peuvent vous choquer parce que vous êtes dans une logique qui n'est pas la mienne. La mienne est une logique juridique. Vous avez une logique en tant qu'archéologue, mais je vais vous présenter le système juridique comme il existe pour le moment et qui gère, et comment les transactions des objets, des œuvres d'art sont le régime juridique, c'est-à-dire de cette transaction-là. Ben, on a discuté au début, quand l'organisation m'a invité, si je fais ma présentation en français, en irlandais ou en anglais, vu qu'il y a des contributions dans l'anglais et en français, j'ai choisi pour l'anglais, mais si vous pouvez m'interroger aussi en français si vous voulez, il n'y a pas de souci. Alors, je vais commencer avec le titre. Black, White, Black, and Lots of Grey. It's a legal analysis of the international trade in art and antiquities. And as I told you in my introduction, I'm a lawyer. And as a lawyer, I think differently. I just said certain ideas might be quite shocking, but it is the law as it is for the moment. I start with an overview of the problem, and the problem is obviously there is art trade. That's as such not the problem, but if you look at the economy of a country in war, you find, or you come to quite straightforward conclusions that the volume of interaction, the volume of trade goes down because the country is in war. There is less volume, import, less export, logic. But I had a closer look at the volume, the trade volume, between Syria and, for instance, the United States. And if you look at that, and you look overall, there is less trade, but if you look at how the types of goods that are actually traded, you see that quite a lot of the current trade is trade in art and antiquities. 46% is all other imports. All the other trade is antiquities, over 100 years old, worked monumental stone mosaics, collector pieces, which is quite a lot. That's the first conclusion of this overview. If you look more closely to the art business, and you look at the Syrian trade from Syria, and trade in Syrian artifacts, you see that it is really a booming business. We often see that when there's a war going on. We also saw that in Afghanistan, with Afghanistan artifacts. There is a booming art business very often. We also saw that during the Second World War. There was a lot of art business going on because these assets are quite valuable on the market, and it's quite they are very often means for people who are in great difficulties to find an income and or pay for an escape route. So trade in Syrian artifacts, it's a booming business. And look at the numbers. If you look between the difference between 2012 and 13 from the region we're dealing with today, if you look at Turkey, it goes up almost 10%. If you look at Egypt, it goes up about 37%, 38%. Lebanon, neighboring country for Syria, plus 59%. And then Iraq and Syria, plus 133 and plus 672%. That's what we see on the market. So that's precisely the problem. And then these objects, they come to the market, and some of them may be illegal, some of them may be okay. The problem is we don't know which ones are illegal and which ones are okay. So all these valuable objects come to the market, small things, coins obviously. You find them on the digital market as well, because these are websites with Syrian coins, or coins at least found in Syria. If you look even at eBay, you find these things. The rare coin from a Pamir site. You can find these things. Also larger artifacts, limestone carvings or marble carvings you can find on the market, and even entire mosaics. The problem is, as I told you, they can be legally okay, but we at least should be suspicious given the fact that the number, the trade volume, is raises questions, or makes us raise questions. The key question in all this, in this debate from a legal point of view, is provenance. Provenance is a notion you'll all know. What is, for those who are not familiar with the concept of provenance, it's the chain of successive owners of a cultural object, or in general the chronology of ownership, custody, location of an art object. The term was originally mostly used in relation to works of art, but now as a wider is applied in a wider field, in similar senses, in a wider range of fields, including archaeology and other cultural goods. Researching provenance is a specialized discipline in art history or archaeology and so on. And obviously, from an art historical point of view, provenance matters, because you get context, you can authenticate certain objects. If you can trace down a painting from the current owner back to somebody who created it, and you can trace it all the way back to Rubens, you are quite, it's not 100% sure, but it says something. And people are willing to pay more on the market for objects with a good provenance, obviously. So art historically, it's important, but also legally, it's important. It started to be important for many decades, or for centuries. We did not really care from a legal point of view, but it became the eye of the storm when the entire Nazi looting problem came to the fore, and its dimension, the dimension of the World War II lootings, forced the market, forced dealers, forced collectors to raise the question and to ask the other party, where did you get this from? Who was the former owner? I need to know where you get it, where you found it. So the difference, ladies and gentlemen, between black and white, the clue or the key to solve that question between black market and legally okay is, how did you get it? Where does it come from? And in the case of Syria and Iraq, we obviously know where it comes from in many cases. It's looting, wartime looting of private collections, citizens, of museums or institutions. As you see, it's not, these are images of the Gulf War, even when the American soldiers tried to sort of occupy and protect the Iraq Museum in Baghdad. So there is organized theft by a system, there is theft by individuals, there is wartime looting of individual collections and museum collections. That's one thing. Monuments, obviously, are destroyed, horrible situations, as you can see here, and you've probably all of you have seen these images of valuable thousand years old these objects that were destroyed, cut into pieces and sold on the market, or destroyed for the cameras. But many pieces obviously were destroyed, but a lot of them were traded too, because they need income. And so they fund themselves. So the things you see on television, on YouTube, on Al Jazeera, the images that are broadcasted, of reportings, that's the things that happen before the cameras to shock, but there is probably much more going on behind when the cameras are not looking and or the world is not looking with them, and so they are destroying and exporting. Illegal excavation obviously is another reason why there are suddenly so many objects. You probably have seen these pictures quite often. These are aerial pictures of sites at the Mari archaeological site in 2011, and if you compare it to a couple of years later, you see dig holes, and there are many. So a lot of the objects that were found in these illicit excavations go to into the trade and end up somewhere in the world. Another site, another image of the Dura Europos site, where a lot of looting pits have can be seen based on aerial images. Okay, we know that the key question is provenance, and so in the current art trade, the provenance question should be raised at all times, as both dealers and collectors better investigate the chronology of ownership of cultural goods they are about to sell. They have to do, as we lawyers call this, a due diligence investigation. This is a notion we, as lawyers, we always know this concept in case when you sell your company, and if you buy it and you buy auctions and you buy shares of a company, you have to investigate whether your company does not have any debts and so on. So this was a concept we knew in other areas, but suddenly this kind of investigation, what is the quality, legal quality of the object we are selling at the market, that's a due diligence investigation, and it suddenly became important because the provenance question is the key question in the international trade in antiquities. Provenance cases, from a legal point of view, are challenging for lawyers, and there are legal reasons for that. It's not to sort of tell to you how incredibly difficult this is. You'll see it's somehow, and I have to put this, I stress the fact that it may seem a game to you, some things we will do as lawyers. Because if you know the legal system, I don't say it's morally okay all the time, but if you know the legal system, you can play the game. And I'll try to play the game with you, so you can see how it works. But because provenance cases are challenging. Challenging because very often when art crime happens, and if you look at that in a global perspective, it's quite, or in a quite interesting number of cases, we manage to recover sooner or later, sometimes centuries later or decades later, but very often stolen works of art, they tend not to disappear. They somehow stay around but remain hidden for quite a while, and sooner or later they will resurface. As this object resurfaced, and the US Immigration and Customs Enforcement Agency found it, and they were quite happy with what they found, obviously, and they showed it to the press, to the world. Well, look, we are actually dealing with this international and this illicit international trade in antiquities from the region we're dealing with today. Other examples of where police forces, custom authorities work together to get these objects, to find them, and to give them back somehow to the original owner. And that is, ladies and gentlemen, very often the key question. Because I have to explain to you today, there is criminal law, but very often this international illicit trade in antiquities, it's not so easy to find the criminals. Those who stole it, those who exported it. It's very often a very long chain in many countries. And that's also what makes it difficult, because it's cross-border business. And it's not so easy to tackle that. But the next speaker will definitely, as given the background with the law enforcement agency, with police, will deal with that. I will look at the trade, because that's a different question. can you be owner of stolen goods? And legally seen, can you be a valid owner of stolen goods? And that's the question. But I still stress the fact that since recovery happens, I don't say all the time, but for many objects we manage to find sooner or later, and sometimes we have to be very patient. We can find they will resurface sooner or later. Cultural objects are everlasting. If I manage to steal this computer at the end of the session today, I won't. But if I manage to do this and take it with me and keep it for 6 years, I'm quite sure that you don't want it anymore. Because after 6 years, it has lost its value. If I manage to steal an apple in a shop, I eat it and it's gone. But it's not the case with art and antiquities. They stay around. They stand the test of time. It's heritage, and they are somehow everlasting. So if you are patient and you have the time to wait, sooner or later they might resurface. I say they might resurface. So as this happened to this painting that was stolen 3 decades ago, and somehow it resurfaced 3 decades later, 31 years later, the the authorities managed to find it. This happened in Brussels. I see there was a page in the Standard, in the Flemish newspaper, but for those who don't read Dutch, well, the thieves bring it back because they did not manage to sell it on the market. It was too well known. It was too famous, this painting. If you steal, you should be modest, because very, very interesting, world famous things, they're hard to market. This was not fit for the market because everybody knew this is a Magritte, and yeah, it's museum quality, and we know where it belongs. So that did not work. And so in the end, they just gave it back. Other objects are easier to deal with. This is quite spectacular as a piece as well, but still, it's less iconic than a Magritte painting. But the police managed to find this. If you look at it, they managed to find this chez un antiquaire belge. But it took them quite a while. After it was stolen in 1980, and so it took them 29 years to find it. Recovery, since these cultural objects are everlasting, you may need to be patient, but somehow it may work out fine in the end. The recovery issue. Find where the object is, but that does not mean that you will be owner, and that is the key question in the trade. Because cross-border trafficking, there's another aspect, a legal aspect, that makes it complex, and I'll play the game with you in a couple of minutes, but conflict of law issues are important. What is conflict of law, or private international law, international private law, the same thing. Conflict of law issues, it's what happens if, for instance, an object is stolen in Syria, it's trafficked by somebody from Turkey, it ends up on the Swiss market, where it's sold by a British dealer to a Dutch collector, and the bank who's funding all that is German. There are many countries which law applies. Is it German? Is it Dutch? Is it Belgian? Is it Swiss? So that's the key question. And if you do know the legal system, we'll see, you can play the game. I'll tell you later. So what law applies, applicable law, and where do you go to seek justice? For instance, if the sale was in Switzerland, do you need to go to the Swiss courts and tribunals, or do you need to go to the Dutch, or do you go to Syria because it came from Syria? So the question where to go and what law applies is a key question in many international business deals, not only because we're dealing with law from a general perspective, and art and antiquities are, for most aspects, they're not different from other types of goods, for most aspects. So a stolen bike, a stolen computer, and a stolen artifact It's the same thing. It's a movable object. And that's governed by the same rules. There are a couple of interesting things to add, but I'll do so in a minute. So what happens, and that is what typically happens, if they manage to find these things back, if they resurface, very often they resurface these objects because the person who originally bought this, a father, he dies, he has 2 sons, and they wonder what to do with it. Well, I don't want it, you don't want it, let's sell it, or we both want it and we don't agree, and let's have an expert look at it, and he'll evaluate the thing, and that's when the problems start. When it's just standing in your living room, not that much happens most of the time, and very often it takes months, years, and even decades. So this happened, and they found it, typically, because they all claim to be in good faith. They found it chez un antiquaire belge qui l'avait acquis de bonne foi. He said, I didn't know. And if he did not know, is he the one to blame? No, because he did not know. If he really didn't know. But what should he? He should raise some questions when entering into a contract. But still, if he really didn't know, if you take it away from him, he paid money, and if you take it away from him and he really didn't know, he lost all his money, and he's not the one to blame because he did not know. And so all thievery, there are actually 2 victims, potential victims. There is the original owner, and if you don't give it back to him, he'll lose. But if there really is a bona fide, a good faith purchaser, if you take it away from him, he paid money and he'll lose. Because what he has to do is he has to find the thief, but the thief is long gone. And if he managed to find him, he may find him in a jurisdiction where it's not easy to tackle him. In Bahamas, for instance, it's not easy to tackle him. Or the funds are not there anymore. So in the end, he'll lose, even if he finds him, because all the money is gone. So if you take it away from bona fide purchasers, then they are the victims of thievery. That is one of the difficult issues in law. And this issue is really a difficult one in law. This is one of the hard cases in law, because in all jurisdictions, if you kill somebody, in all jurisdictions, the answers will be quite similar, because you need to be punished. If you steal, it will be quite similar. If you don't respect the contract, it will be quite similar. But countries differ with regard to this issue, because shall we favor the original owner, or should we favor the one who bought it on the market and who is not to blame? Because if he's to blame, that's another discussion. Then, obviously, it's not entitled to the object. But if he's not to blame, what shall we do? And so there is an opposing view, a clash of legal systems. And on the one hand, there is the Anglo-American world. And what I tell you now, this is the contrast in real life is a bit less. But overall, what I tell you now is correct. That in the Anglo-American world, so the common law system, which means the Anglo-Saxon bloc, legally seen, that's obviously the UK, Ireland, we talk about India, we talk about Canada, we talk about the United States, former colonies of Great Britain, of the United Kingdom. The Anglo-American world, they look at these issues and they always say, well, you can't transfer title if you're not the owner. And if a thief who steals it, he's not the owner, so he does not have title. And if he sells it to somebody, even to somebody who is in good faith, he will not be owner. And even if somebody who bought it in good faith and did not know and passes it on and on and on and on, there is no title to transfer. So the result of that is that, in theory, a theft that happened in 1622 and was sold time and time again on the market, up till now, is potentially not okay, because something happened in the past, and it was taken away from somebody who, and there was no title, and it was passed on and on and on, but there was no title to pass. So all objects are somehow legally seen in limbo. What happens? What should happen to these objects? On the other hand, there is a civil law world, and the civil law world is the continental European world, more or less. And we have a different view, a completely different view on this issue, because what we try to do is what we call, as lawyers, favor commerci. We try to favor the trade. And if you want to favor the trade, that means that if the circumstances in which somebody bought an object are okay, then it would not be good for the trade if these deals could be revoked somehow later on, because everybody is somehow lives in a certain situation. And so you have to favor the trade, and what we will do is we transfer ownership of stolen goods, even stolen goods, and it's still legally possible under certain conditions. We don't do that automatically, but certain conditions have to be met. If you have to, if you manage to reclaim the object, if the conditions are not met, there is redress against the seller, obviously, because then you pay for something you never got. But that's not easy, as I told you, because very often the seller is gone. Protection of the trade in civil law countries is the system, and I'll just show you two mechanisms, how it works, and the conditions that apply or that are important aspects in order to have a valid deal. There are two mechanisms, and this is an important thing to focus on. Either you transfer objects through a contract, through a deal, a business transaction. I sell an object. So, and if you are in good faith, you acquire it in good faith. That's the first mechanism. Bona fide acquisition from somebody who happens not to be the owner. It's a non domino. There is a second mechanism, which is called adverse possession, which is what we call on the European continent acquisitive prescription. This is a situation, there is no deal, but I have an object and I kept it with me for long enough. So even if I just found something on the floor here and I take it with me and I wait and wait and wait, if I wait long enough, it's going to be mine. The other thing is, if I meet somebody who sells an object to me, I pay money, I'm in good faith, that's the second mechanism. That is the first mechanism, bona fide acquisition a non domino. The second one is, if I happen to have an object for quite a while, then in the end, even if it's not, in the beginning it was not my owner, I was not the owner, in the end I will become the owner. The transfer of ownership in both cases is dependent upon, subject to a number of conditions. Being in good faith is crucial very often, but also you have to wait a bit, lapse of time. You have to possess your object openly. Hiding it away in a vault is not a good solution. But if you use it openly, court says having it in your living room is okay, because that's a normal use of art objects. But that's not so open. It's not that you have to publish it all the time on the website, look what I got. So circumstances of the sale, capacity of the former owner and the buyer can be important, and the nature of the goods. I will give us some examples, and you'll start to play the game with me in a minute or two. Imagine that this object was stolen in Belgium some time ago, and it was on the website that we're now looking for it. And maybe it's in the meanwhile it resurfaced and they managed to get it back. But imagine what happens if this happens in Belgium. If the object was sold to a bona fide purchaser, so if there was a transaction, then the original owner can obtain recovery within 3 years, starting from the theft. So it was stolen today. If you come to see me and you find it back, and I bought it in good faith, and you come to see me in 2020, it's over. It's mine. And I'm legally seen the only owner and legally the only one who is entitled to the object. And that may be shocking, because in 3 years' time it's over. But that's the legal system. Even if you find me within 3 years, if I bought the object in the regular trade, so if I bought it in an antique shop, if I bought it on auction, in an auction, you are entitled to get it back only if you come within 3 years, but even in that situation, you still need to pay my purchaser's price. The price I paid, so you need to pay, you need to buy your object back. Because logically, I didn't do anything wrong. I was in good faith. I did not know, I could not have known. If you just take it away from me, I'm the one who is the victim of the thievery. And I'm not the one to blame. So if you come in time, I will give it back to you. I do understand that it's valuable to you and you emotionally are somehow attached to the object, but I only give it back, and legally seen, I only have to give it back if you pay my the price at which I bought the object. And then 3, if there is no transaction, if I just keep it long enough, even without a transaction, even when I'm in bad faith, so even if I'm the thief and I wait long enough, I become the owner. 30 years time after the theft. It's quite a while, but look at the examples. The examples of 31 years and 29 years, it happens on the market. How is it in France? Same thing. Exactly the same thing, because these provisions are a copy of the Napoleonic Code and they just have the exact thing. It's the same in Luxembourg as well. Switzerland, ladies and gentlemen, it's the same thing, more or less. 3, 4 details to mention, but the main idea is the same thing. But it's not 3 years, it's 5 years. But after 5 years, it's over and it's done. You never get it back, because the only one is entitled to the object is the other party, the one who bought it. German situation, ladies and gentlemen, and look at the conditions that play actually in order to get the ownership. You always need to be, or at least if you are bona fide, if you are in good faith, it goes rather quickly. Recall the Belgian situation, 30 years if you don't have good faith, but if you do have good faith and you bought it, it's 3 years' time. It goes quickly, if you are in good faith. So when stolen goods are sold to a bona fide purchaser, they say, in Germany, there is no transfer of title. And that seems quite good, because that seems fair, you might think. But there are a couple of other provisions in the German code, and they say this: if the stolen property is sold at auction, and the good faith purchaser will be automatically the legal owner. So where you bought it is in the Belgian system an important thing to decide: do you have to reimburse the purchase price? It's not the same thing in Germany. This aspect is also crucial, but it decides whether you have to return it or not. So if you bought it in the public auction business, you're safe. People like to buy on auctions because they're immediately safe. And the public knows that. So if the stolen property is sold at auction, you can't reclaim it. And those who have it in good faith, even without a transaction, even if you didn't buy it at auction, after 10 years' time, you'll be the owner. It's quite a mitigation from compared to the first rule. There is no transfer of title when it's stolen goods. But then they say, but after 10 years' time, yeah, okay. But 10 years' time, that's rather quick. So the Netherlands, ladies and gentlemen, if the object was sold to a bona fide purchaser, he can obtain recovery within 3 years. That's like Belgium. If the object was sold to a bona fide consumer in the regular trade, even larger than auction trade, it's automatically transferred. The ownership is automatically transferred, so it's over. If you buy in an antique shop in the Netherlands, it's over automatically, if you're in good faith. No recovery after 10 years if you have bona fide possession, so even without a transaction, but 20 years if you're in bad faith. That's 10 years sooner than in Belgium. And then, ladies and gentlemen, Spanish situation is very interesting too. Stolen goods are sold to bona fide purchaser. There is no transfer of title unless it occurred in the regular trade. Okay, because we want to favor the trade. If the object was sold to a bona fide purchaser at auction, then there is, even if it was even if it occurred if it occurred in the regular trade, there is direct transfer of title. But regular trade in Spain is not considered auction trade. Auction trade is something different in Spain. But they say, well, if it's at auction that it happens, then you're still entitled to the purchaser's price. So, and recovery, and that is extremely fast. No recovery after 3 years, bona fide, and 6 years if you're mala fide purchaser. Mala fide possession, even without a transaction, is if I find an object and I keep it for 6 years, it's over. Ladies and gentlemen, Italy, the champion of the market. If the object was sold to a bona fide purchaser, legal title is immediately and irrevocably transferred. So I advise my clients, let's buy in Italy. But we need to be sure that we're not to blame. So we need to investigate. But if everything we checked is okay, and we do this seriously, but if everything we checked is okay and we didn't know and we could not have known, I am able to confer title upon my client. And he's willing to pay for that. He's happy to do that. And so if you start to play the game, you'll see how you can start to play the game if you know these rules. So far we discussed the general rules on property law, regardless of the fact whether you sell bikes, computers, or works of art. But obviously that is not a complete picture because many countries have restrictions, special policies. They developed heritage legislation to have a deep impact on property law because they say, well, this is too easy. Makes sense. This is too easy. Okay. What do? Well, they develop policy measures and created various types of heritage protection. I can't go into detail, but what is important, there are rules in most systems to prevent the transfer of title on stolen heritage. Because the mechanisms I told you, like wait 3 years in Belgium and we start to count as of the day of the theft and we wait 3 years, in the end, I mean, it's not that long, it's not so easy. If the object was stolen in Syria, I'm quite sure that the Syrians won't be in time to find it here if it's just hanging in or standing in a private home. 3 years' time, but then we say, no, that should not be the case, that is too quick. So we stop the transfer of title of stolen antiquities and cultural heritage. And obviously, there are rules to restrict export because we want to keep objects in a certain country. That is what we want. If you want to export this object from Belgium, it won't happen because government won't let you. Because they know this is the Van Eyck work. It should be in Ghent, it should stay in Ghent, and you can't export it. And even the idea of let's steal this panel. It somehow happened. And we never found it back. If you find it, even if you bought it in good faith, it will be quite difficult to be in good faith because it's quite famous, but if you bought it in good faith, you won't be the owner. But now, this is not only in Belgium the case, because we have it it's something that is not dealt with at the federal level, it's within the Belgian difficult public law system. Our federal government does not deal with culture issues, it's for the communities. So the Flemish community and the Francophone community, they deal with it, and they both have legislation. And they're not alone, because in the world, I just made a quick list for you. There is the Gesetz zum Schutz deutschen Kulturgutes gegen Abwanderung, which means the protection of cultural goods from Germany against illicit export. Germany, Austria, Switzerland, the Netherlands, France, Italy, Portugal, Spain, Greece, UK, Ireland, Sweden, Egypt, and I can go on and on and on and on, because all countries, most of them, have this kind of legislation. But not the US. The US does not have limits on the trade, because they favor trade, and they welcome the idea that objects circulate freely, move freely on the market, and come to the US. So they also allow US objects to go away, to be sold without any limitation. all these national differences, because you don't have the regular rules, not only the regular rules on property law, but also the rules on protection of heritage, they are quite different from country to country. And as I told you in the beginning, in these international cases, we have cross-border cases, that's where the things start to go wrong. Because we always wonder what law should apply, what tribunal should we go to. Our trade is very international, and we have a rule for that. We have a solution, because this is not a problem typical to art business, it's for all international business the case. And our rule is, the guiding principle in these conflict of law situations, which law shall we apply? These kind of discussions about property are always solved by making use of the rule lex rei cite, which is the idea that a legal doctrine that the law governing transfers of title or to property is dependent upon and varies with the location of the property. So I show you the provision, which is or the translation of that idea into our Belgian code, the Code of Conflict of Law Code in Belgium. It says, les droits réels sur un bien sont régis par le droit de l'État sur le territoire duquel ce bien est situé au moment où ils sont invoqués. So, if your object is in Belgium, we apply Belgian law. If your object is in Germany, we apply German law. If your object is in the UK, we apply UK law. Where the object is. Okay. And it's not only Belgium that does this. This lex rei cite rule is an international principle. Most countries, there are very little exceptions to that rule. So the US, the UK, Belgium, France, Germany, Italy, they all apply this system. The consequence is this. The problem of mobile conflicts. Because location of the goods is crucial. The problem is we're dealing with movables, so they move. As long as we're dealing with houses, they don't move. And so that a deal with regard to a Belgian house is dealt by Belgian law, that's quite straightforward because we're in Belgium. But movables, they move. And they will cross borders. Legislation governing objects will change each time you cross a border. And that is quite a complex situation. Lex rei cite only applies for the time that the object was in a certain jurisdiction. And now it starts to be complicated. Imagine we have an object that was stolen in Belgium. If during the first 2 years the object, for instance, was sold in Belgium, the sale in Belgium will be dealt with by Belgian law, under Belgian law. But let's imagine that the next day the buyer takes it to France. What law will apply? Well, suddenly French law will apply. And you always apply legislation for the time the object was in that country. That's why, precisely as a lawyer, I'm very interested in provenance. I'm very interested in who did have the object, when and where, because it determines the legal regime. If this object was for 227 days in Belgium, these 227 days will be governed by Belgian law. If they took it 1 day to the Netherlands, it's 1 day the Netherlands. Then they move back to Luxembourg, 3 days Luxembourg. I move with them, and that makes it complicated. So, l'acquisition, la perte de ces droits sont régis par le droit de l'État sur le territoire duquel le bien est situé au moment de la survenance des actes ou des faits invoqués pour fonder l'acquisition. So if I sold the object in Belgium, imagine this case. It's a stolen object. I buy it in Belgium, even if it's stolen in Syria. I buy it in Belgium and I stay in Belgium for 3 years. I will conclude. I stay in Belgium for 3 years. It's over. Because I know, as of the day of the theft, they have 3 years to come to see me. I had it for 3 years in Belgium. It's done. But I can play the game. I can move it to Italy, and it's immediate. Or I could go to Spain if I have hesitation with regard to my title, and after 6 years, even if they tell me that I'm in bad faith, it's over. So you can play the game. And that, ladies and gentlemen, is precisely what happens, and that is something that deeply impacts the heritage protection, because if an object is protected and is normally not subject to the rules I just discussed with you because it's cultural heritage and transfer and title cannot be transferred. Imagine the mystic lamb I showed you. The mystic lamb is protected in Belgium. But the difficult issue is the second you bring it to France, all protection disappears because suddenly French law will apply and hey, this object is not listed in France, it's listed in Belgium. And if you move it, a Syrian object, protected Palmyra object, if you protect it in Syria, the moment you bring it to Turkey, it's over. Because Turkish law will apply, and they look at the list, and unfortunately, Palmyrian objects are not in our list. So it's over. That is the difficulty. All protection is lost when goods go cross-border. The European Union knew that, because in 1992 we abolished all borders. There is no border control on the European continent here. So I can take my Rubens painting in my car, drive to France. Who will stop me? Because there's no border control. But the minute I go to France, there is no protection for the object anymore. That was the huge problem they had when they abolished border controls. So the EU said, we need to stop this. We need to keep all objects within the European Union, and there is a regulation for that, prevent them to be exported to the United States, for instance. So there is heavy control at the exit zone of the European Union, and we believe that sooner or later they will resurface if we keep them inside. So we have a restitution policy that obliges member states to recognize the Spanish, the Irish, the British legislation with regard to heritage protection. And then the importance, and that's my last slide, ladies and gentlemen, what does UNESCO do? Well, UNESCO does what the European Union does at the global level. Because we give objects back, objects that went cross-border, and normally seen we would not apply Spanish law in Belgium, and so consider objects not special, because under Belgian law, they're just not enlisted. But we say, oh, but you're a member state of the European Union, we'll do that, because you're the European Union. And we'll give it back. And UNESCO, the importance of the UNESCO Convention is, from a legal point of view, that we'll start to do that not only among EU members, but we will enforce restrictions from Syria also in Belgium. We'll enforce Australian restrictions in Belgium. And that is the importance of this convention. Legally seen, without it, the second you go cross-border, it's over, and you can't reclaim it. And that's precisely what happens in Article 7. I don't go into detail about Article 7, but that is what happens. So, ladies and gentlemen, my last slide is this. Conclusion, international trade. There is black trade, which is originally not okay. But sometimes even black trade becomes white if you wait long enough. But if you move it to the wrong country, it returns to black. Because an object, for instance, that was national heritage in Belgium, was stolen, was sold in France. As long as it stays out of Belgium, it's okay. The second you bring it to Belgium, it's again listed. And say, hey, this can't be yours because this is protected. It will become black again. But for many people and many customers on the market, they have gray situations because they never know, am I entitled? A lot of goods are in limbo. Some of them, after 29 years, are close to white. Others are still very close to black. But many are gray. And that's the problem. Thank you.